Mr. Deepanshu Singh. The world has witnessed a long struggle for establishing power through democratic processes. The troubles sustained by many generations in various countries, which were under the rules of dictators, authoritarians, and tyrants, is unfathomable. In the Indian history itself, one can find ample of examples during the Muslim rule or the British rule of cruel policies like imposition of exorbitant taxes being levied on the population only because the population had no political rights. This being the position, the makers of India, right from the very moment of independence, assured to every citizen political rights and freedoms. The country was established as a democratic republic on 26 January 1950, which gave all the powers of electing the representatives of the country in the hands of the people. Therefore, to preserve this great gift of democracy, it is absolutely essential that the process of democratically electing the representatives should be understood by every person of our country. John F. Kennedy, the former president of United States of America, has said that the ignorance of one voter in a democracy impairs the security of all. And so, to enlighten our young voters and to educate them about the structure and related concepts of elections in India, the election system in India, Dr. D.Y. Patil Law College, Pimpri, Pune, in collaboration with Think India PCMC, has organized this interesting guest lecture. I am very sure that this will be a brainstorming session, and so I call upon Ms. Akanksha Singh to give a welcome note on behalf of Dr. D.Y. Patil Law College as well as Think India.
Thank you, Judy. I, Akanksha Singh from first year LLB, first of all like to thank our college for always encouraging students and giving me opportunity to give a welcome note. Here, a hearty welcome, big and warm welcome to encompass you all on the behalf of Dr. D.Y. Patil Law College. It's immense pleasure. It's immense pleasure to start this session by heartily welcoming everybody. I welcome our chief guest, our principal ma'am, and my professor and my fellow colleagues. A brief introduction about Dr. D.Y. Patil Law College. Dr. D.Y. Patil Law College was established in year 2001 under the patronage of Dr. P.D. Patil sir. The objective of Law College right from inception has been to promote and feel the togetherness, caring, sharing, and understanding between the students from all states. The motto of Dr. D.Y. Patil Law College is to encourage students to participate in various events and show their talents. Anything it may be today, but you have to give opportunity to shine and show the world who you really are. Dr. D.Y. Patil Law College train and develop students to be good and able citizens capable of making significant contribution towards meeting the priorities of nation. A brief introduction about Think India. Think India is a national forum of students, alumni, and faculty from several premier institutes with the several academic disciplines. Think India have felt need to bind students with an Indian nationalist string to harness this part of national treasure. In furthering our aim of national reconstruction, Think India's initiative to get the best talent from a finest institution with a broader objective generating ideas and view geared towards national rejuvenations and inspire young minds to take upon themselves their responsibility in a progress of nation building. Think India creates an ecosystem for youth, organization, and individual who are working in a favor of national interest. We run various internship initiatives such as Niti, Vidhi, Anubhuti, Samvad, Sansadiya, etc. And also various forums such as International Relations Forum, Governance Forums, Human Rights Forum, Economic Forum, etc. to reach each and every discipline. Today we are here with very grateful to have a Deepanshu sir on our platform. And I am sure it will be a great intellectual treat for all the students over here. I call upon Ms. Julie Patwardhan to introduce about Mr. Deepanshu Singh. Thank you.
Thank you, Akanksha. The guest speaker for today's session is Mr. Deepanshu Singh. Mr. Deepanshu is an Indian educator, author, guest columnist, guest speaker, and consultant with the Government of India and the Government of UP. He has mentored some of the top rankers in UPSC and CSE at Unacademy. Mr. Singh has authored the book International Relations, Interests and Challenges. He has delivered and continues to deliver guest lectures at IITs and IIMs. I think it is a great privilege for all of us to be listening to such a great speaker this afternoon. And so, without any further ado, I invite Mr. Deepanshu Singh to conduct today's lecture.
Hi everyone. Good afternoon, everyone. Am I audible? All right. First of all, I would like to thank Think India and especially Dr. Ujjwala, Principal Ma'am, for giving me this opportunity to share my thoughts on this very interesting, but I consider it as a very challenging topic also. Talking about electoral system in India and at the touchstone of democracy. And at this very moment, I would also like to thank all the organizers of this webinar. Considering that we are in a pandemic scenario, I would have loved to come to your college and deliver a lecture. I personally love to, interact with the audience a lot. But then nevertheless, considering the scenario and the situation, I think it's best that we, can have these kind of sessions organized by a platform like Think India and by your esteemed college. I'll be talking today on the topic which has been given to me on electoral system in India, and I can consider myself extremely lucky, and it's a great privilege for me speaking to all of you, especially considering that all of you are law students, and it's always a challenge speaking in front of law students and on these topics which are burning issues at the same time concern each and every citizen of our country. So what I'll do is I've made a small PPT just for, so that it becomes a little easier for all of us, and I'll share my screen. I think the host has to enable the screen sharing for me so that I can show the PPT and we can start the session.
Please check, sir. I guess you are able to share.
I think the screen is visible to all of you.
Yes, sir.
Yeah. All right. So we're going to talk about. I'm going to share by be sharing my thoughts on electoral systems in India. I think first of all, I would also like to thank the organizers for giving a very kind introduction. I think that was very kind of you to give that elaborate introduction about me. But personally, I don't think so that I achieved so much. I'm still a learner, an educator at heart, but still learning every day new challenges, especially because considering how law keeps on evolving. I am a very keen observer of Supreme Court judgments and High Court judgments, and I keep updating myself every day. So every day there's something new for me to learn from whatever is happening, at least around in the law community. But having said that, I'm also honored that. Or rather privileged that I have been able to write a book, which is one of the best sellers in the UPSC field on international relations, because that is one of my interest areas. And I was fortunate to have Syed Akbaruddin sir. He was a former permanent representative of India at the UN. So he was kind enough to write the foreword for the book and was deeply appreciative of that fact. So before we begin this topic, I would like to highlight a few things about elections in India. Just a few numbers, just so that we can set the tone of the topic. So if you see the numbers of election in India, the 2019 figures, the latest general elections, there were 900 million registered voters, and there were 11 million election officials that were engaged in this huge, one of the most mammoth exercise of democracy in the world. So India is the world's largest democracy. And we make it a point that even if there is even a single voter, staying in one of the most remotest areas of Ladakh, the election commission ensures that we reach to that person, because what we believe is in the power of voting, and we believe in a democracy, and a vibrant democracy like India, even a single vote matters. But at the same time, considering we have done made such advancements, we have made such an effort of making India such a vibrant and flourishing democracy, there are certain concerns as well, which I would like to highlight in the course of this lecture. Firstly, if we see the numbers, for example, there were 67%, 67.11% voting turnout, which was the highest ever in general elections to India. But at the same time, the concern is that in the recent democracy index, India has actually slipped its position. At the same time, as per the report published by one of the non-profit organizations working in the field of electoral reforms, the ADR has mentioned that most of the candidates that are given preferences in elections have a criminal background or have some sort of criminal cases pending against them. And interestingly and shockingly also, it's one of the highest in the past few elections. At the same time, one of the most recent data is on electoral bonds. This is itself from this month itself, last month on 27th of August, that electoral bonds worth more than 3,429 crores were redeemed by parties in 2019 and 20. Now, this is again by report published by Association of Democratic Reforms. So having said all of that about the entire system and considering also these numbers, we have a lot to think and ponder upon. So let's start with first a few basics about the election system in India. So as you know, India is a democracy, and democracy comes from the Greek word, which means demos, which means people, and kratos, meaning power. So in India, we believe in a system where the power flows through the people. And once we read the preamble of the Constitution of India, the first line starts with itself that we, the people of India, having solemnly resolved. So the idea is that in a democracy, the power should always flow from people, and it is meant for the people. And that is how our governing system functions accordingly. And if we go to the history of elections, the earliest elections used to happen in Greece, that is in Athens, but the kind of system was based on a system of plurality of vote. And it was not very much preferred. Later on, the Romans improvised it. In the Venetian method came into the picture, in which they had a different system altogether, where the election happened through the drawing of lots, somewhat similar to what we have during the presidential election in India. Later on, much later in the 18th century, the US, which had one of its first constitution, they devised a system of election, and they have a system of election where the democracy functions on the basis of presidential system of elections. India, of course, has a parliamentary form of democracy, where parliament is one of the most supreme bodies, which is entrusted with representing the will and the aspirations of the people of India. So having said that, why do we actually need democracy? Now, most of the time when I am teaching polity and constitution in my lectures, in my classes, when we start the topic of elections, I have noticed a lot of things about, in general, about students. And I think it's pretty common among law aspirants also, law students also, that we might know about elections, but what is the basic nature of our democracy, and why do we actually need a democracy? Because nowadays there is a lot of debate happening that does India need democracy? There was a recent comment also that India mein bahut zyada democracy bhi hai. So we have too much of democracy also. So considering those viewpoints, why do we think that we need a democracy in India? First of all, democracy promotes individual autonomy. That idea that no one should be subject to rules which have been imposed by others. And second most important fact why we need a democracy is that it ensures equality. Idea of justice and equality is ensured by democracy. So having these principles and following these principles, India adopted a parliamentary form of democracy. Our constitutional makers in the Constituent Assembly decided for a parliamentary form of system, Why also? Because we were pretty much used to it during the British Raj. We had already experienced the kind of system that they used to follow. So our form of parliamentary democracy is based on the Westminster form of democracy that is followed in the British Parliament. However, there are a lot of similarities too, but there are a lot of differences also, which I'll be talking about, especially in the context of elections, also in Britain and India, that I'll be talking in the course of this lecture. So in India, the elections are carried out by a body known as the Election Commission of India. We have another body that is called as the State Election Commission. But the State Election Commission is only concerned with the elections to the Panchayati Raj institutions and the urban local bodies. So they are not concerned with the elections of the president or the vice president or the state assembly. So the Election Commission of India, the constitutional body, is one of the bulwarks of the constitution, as said by our Dr. Bhim Rao Ambedkar Sahab. He said that Election Commission, along with the Supreme Court of India, along with the UPSC and the Comptroller and Auditor General of India, these four constitutional bodies are the most important constitutional bodies in India, and they are the bulwarks. Why? Because they in the future will prevent the constitution from becoming weaker, and they will prevent you can say weakening of democracy. At the same time, they will rise up to the challenges and occasion to prevent, like how a ship is prevented by strong waters of the sea through the bulwark. Same way these four institutions will work. So Election Commission was one of the most important institutions as envisioned by our forefathers. So during the British rule, if you see, women earlier were enfranchised on the same terms as men under the Government of India Act to vote in 1935. And it is the beauty of our democracy that after independence, India is probably only the few countries where everybody got a right to vote, irrespective of caste, creed, gender, community, sex, religion, etc. In fact, women in Western parts of the world, in America and Britain, had to fight for their right to vote. So considering that, that is why we say that India is one of the most vibrant democracies and was one of the first democracies where people got a right to vote immediately once this provision became active. So in India, we follow a system which is based on the concept of adult suffrage, that anybody who has turned the age of 18 and is registered into the electoral rolls is eligible to vote in India. Now, talking about the body entrusted with this task is the Election Commission of India, which is right now a multi-member body, but earlier it was not supposed to be that way. It was earlier conceived to be a single-member body. So the Election Commission of India was established in the year 1950 as a permanent independent constitutional bodies, which had the power of superintendence, control, direction. And this is all mentioned in your Article 324 of the Constitution of India. So initially, the body was supposed to be consisting of a single member, the Chief Election Commissioner only. But then considering, how the population grew, the challenges grew, and it was very difficult for a person or a single person to manage the entire electoral processes of India. So there was a need felt that we should have more election commissioner. So the president, from time to time, it's on his discretion, can increase or decrease the strength of the Election Commission of India. So on October 16th, 1989, for the first time, 2 additional commissioners, election commissioners, were appointed, but they had a very short tenure till January 1st of 1990. And later on 1st October 1993, 2 additional election commissioners were appointed. So the concept of this multi-member commission has been in operation since then, with decision-making power by the majority of votes. So right now we have 3 election commissioners. One is, of course, the Chief Election Commissioner, but all the decisions are taken in unanimous through, a majority vote. But there are certain concerns about how the Election Commission functions, and we'll come to that when we're talking about the challenges related to Election Commission of India. So the person that you see in this image is Mr. Sukumar Sen. Shri Sukumar Sen was the first Chief Election Commissioner of India of independent India. And since it has been functioning as a single member body, and later on 2 more were appointed. So under the clause 2 of Article 324, the Election Commission will consist of a Chief Election Commissioner. It can never function without it. There has to be one person who will always be the Chief Election Commissioner. Apart from that, you can have 2 other election commissioners from time to time, depending on the president may desire. Similarly, Article 324, subclause 5 says that the Constitution was incorporated to ensure independence of the commission and freed from external and political interference. Now, strikingly, election commission is supposed to be an independent constitutional office, but most of you will be surprised to know that it does not have its own secretariat. That means it cannot appoint its own staff, and that has been one of the biggest challenges for election commissions of India. In fact, most of the former chief election commissioners have been demanding certain amendments to the electoral laws, which we'll be talking in in due course of time in this lecture, about how we can strengthen our democracy further and how we can make this electoral process a much more efficient process. So there are certain electoral laws through which your elections are conducted in India. One of the most important is the Representation of People's Act 1950, which was enacted in the year basically to make basic laws about election. But then it did not really talk about provision of electoral, provision of how somebody can be qualified or disqualified. So there was a need felt to make a new election law. So then Representation of People's Act 1951 was enacted, which in detail talked about the conduct of elections and related to matters of post-election disputes. Now, Supreme Court over the period of time in P.N. Seshan case, and whether it's the case related to any electoral matters, has highlighted multiple times on multiple occasions that if in case there are no laws available, the Election Commission will have the residuary power under the Constitution to act in an appropriate manner. And that is why you see a lot of time when there is no specific law mentioned on a certain issue, the ultimate body which has the power to decide on things is the Election Commission of India. So talking about the functions of Election Commission of India, most of the time we think it's just about conducting election. Conducting election is not a small exercise. It comprises of a lot of things that has to be done before and after. In fact, I think just before this lecture was about to begin, Election Commission of India has issued a new date for bypolls. So I think that was a very fitting moment, because just we are going to talk about this topic and the Election Commission has announced something about bypolls. So having said that, so Election Commission of India has the responsibility of conducting election firstly for the Lok Sabha, secondly for the Raj Sabha, the state assembly elections of all the states in India, including UTs which have a legislative assembly. They are also responsible for conducting elections to the office of the president and the vice president. And doing so, they have to do certain tasks, like they have one of the most important tasks of maintaining and creating the voters list. So the Election Commission supervises this in preparing an up-to-date voters list. They will carry out this exercise time and again to make sure that the voter list is updated and intact. Secondly, as I mentioned before, the other task of Election Commission of India is to ensure a proper schedule and timing. Now, when we say that India is a vibrant democracy, or India is a democracy where electoral processes are given due importance, one of the most basic features of conducting elections in India is ensuring that the elections are conducted in a free, fair, and transparent manner, and most importantly, in a timely manner. उस इलेक्शन का कोई फायदा नहीं है अगर वो सही टाइम पे ना हो और अगर वो फ्री एंड फेयर ना हो. Then it's not a true democracy, and then there is no need of an election also, because then it doesn't serve the purpose. So to ensure that we have a free electoral process, it's a fair electoral process for everyone, irrespective of whether they are rich or poor, whether they belong to a certain gender, caste, or community. This is the main responsibility of Election Commission of India, and that is why they are working tirelessly day and night to ensure this, that there is no hiccups in this. Similarly, to one of the aspects of ensuring free and fair polling in India is the enforcement of this model code of conduct. Now, model code of conduct is not a law, contrary to what a lot of people believe. But knowing the fact that most of you are law students here, though there are other students also in the session, I'm pretty much sure. Model code of conduct is not a law. It does not have a statutory backing. It's just like an MOU, understanding between the political parties, the candidates, and the Election Commission of India, that a certain set of rules and guidelines will be followed while during the conduct of election, which does not jeopardize the electoral process in favor of a certain candidate or a political party. Similarly, they also, the Election Commission of India is also entrusted with the responsibility in case if there is a chance of repolling or recounting, or even, as I mentioned earlier, about bypolls, when, let's say, there's a possibility of a elected member vacating the seat due to electoral defect, maybe due to anti-defection law, or maybe because of death and vacancy of the seat, then one of the most important powers of Election Commission India, apart from all of this, is also the recognition of party symbols. This was recently highlighted in the Samajwadi Party case, where the ultimate deciding authority lies with the Election Commission of India. Now, why I consider it as one of the most important power also is because there is no such judicial review applicable in the case of when the Election Commission is deciding this matter on recognition of party symbols. So whatever the Election Commission will decide will be final and will have no opportunity of judicial review in any court in India. So, these are some of the functions that Election Commission is entrusted with, apart from ensuring free and fair elections in India. So, as I mentioned about model code of conduct, this is basically to ensure that the elections are conducted in a more convenient manner without any, you can say, in a fair and transparent manner. And the rules are, very elaborate on, let's say, symbols. Their rules are very elaborate on what has to be done pre-poll, post-poll. All of those things are covered in model code of conduct. Then one of the most important provisions of our constitution is Article 326, which is talking about right to vote. So right to vote on the basis of adult suffrage is given to every citizen of India on the basis of Article 326. Mind you, it is not a fundamental right, neither it is a constitutional right, though there are some controversies regarding this. But because Article 326 is an enabling feature, it gives the opportunity for every citizen who is eligible to vote. Later on, because there was a need which was felt to subject it or limit it on the basis of certain practices. So that is why there are detailed provision regarding voting available in the RPA 1951. For example, if you are in jail, you cannot vote, but irony of India is that you can contest elections. तो अगर आप जेल में बंद कर दी जाते हो तो आप वोट नहीं कर सकते, but irony है कि आप election लड़ सकते हो. So those are things probably which will take some time. In fact, Supreme Court and the high courts of India have highlighted this multiple times that we need to look into this, and this is in the domain of legislature, because as you know, under doctrine of separation of powers, the executive, the judiciary, and the legislature, they have their own task. The role of judiciary is only to interpret the laws and probably check on the excessive powers of the state. The main power or the main task of making laws is with the legislature. So ultimately, it falls under the domain of the parliament to ensure that there are certain laws or the RPA is suitably amended to check on these things. Similarly, apart from this, there are other laws also which we'll be talking in this lecture. For example, election conduct rules. So I was mentioning about the RPA Act. So RPA Act of 1950 basically gave a brief idea about how the Election Commission should appoint and nominate the chief electoral officer, how the allocation of seats should happen for Lok Sabha, the assemblies. Similarly, appointment of district level election commissioners, how it should be done. So basic idea, about election. But there was no such mention or provision about how, in case of any discrepancy, how the electoral, issue should come into the picture, or, whether there is some issue regarding disqualification offenses, how that should be dealt. So for that, RPA Act of 1951 was, enacted. And majorly, I would say more than 1950, the major law that has a significant impact right now in present times on elections in India is the Representations People Act 1951. There are multiple sections in this which deal with free and fair elections, that talk about the political funding, that talk about seeking whether we are seeking a vote in the basis on the name of religion or caste. Similarly, there are provisions regarding registration of political parties, deregistration of political parties, apart from other electoral laws like the registration of election rules 1960, the conduct of elections rule 1961, the election symbols order of 1968. So the registration of electoral rule 1960 basically talks about how the voter ID card will be issued, etc., and what all details will be there. Conduct of election rule talks about filing of nomination, scrutiny of nomination, about the returning officer. Election symbols order, as I mentioned previously, talks about how the electoral symbols are allocated in India, and the final authority of in case of a dispute lies with the Election Commission of India. Now, if we talk about some of the concerns that plague or affect the Election Commission of India, one of the most important is the budget. Now, when we talk about the constitutional bodies in India, the constitutional bodies are free and fair and independent. One of the most basic features on how do you ensure independence of a body is by giving them autonomy. How do you give autonomy? You give them powers. At the same time, apart from autonomy and giving them powers and function, one of the most essential features of ensuring that the body functions without any pressure or functions without doing any unfair practices, or functions without any pressure or external pressure of doing some sort of favor, is giving them a free hand in their budget. Now, this is very surprising for a lot of you. It might be a lot of surprising for a lot of you people, but you might know that there is a concept called as charged expenditure in the budget of India, in the annual financial statement that is presented under Article 112 every year. And in those presentation of budget, when we present the appropriation account and the finance account, so in the in those expenditure, there's a list of budgets which are votable and not non-votable. Certain budgets, like the budget of the UPSC, the Comptroller and Auditor General of India, these budgets are non-votable. That means the Parliament can only discuss the budget, but they cannot vote it down. Now consider this, that Election Commission of India, if not, is one of the most important constitutional body in India. And it's very shocking that their budget is not a charged expenditure. So they do not have a separate secretariat. They cannot appoint their own staff on their own. And in fact, this has been a very long-term demand of former election commissioners and chief election commissioners, that the budget should be made as a charged expenditure. So you can say that right now the Election Commission functions on the basis of whatever budget is allocated to them under the annual financial statement passed through the Parliament. So that's the first major issue concerning the election in India, or Election Commission of India. The second that I had mentioned is about the appointment of staff. So regarding this, there was a very famous committee, the Goswami Committee. It had reported in its 1990 Electoral Reforms report that the protection of salary and the other allied matters relating to the Chief Election Commissioner and the election commissioners should be provided for in the Constitution itself, on the analogy of the provision in respect of Chief Justice and the judges of the Supreme Court. So as you know that the salary of the judges of the Supreme Court, the High Court, all of them are charged expenditure. In fact, the pensions of the High Court judges are charged on Consolidated Fund of India, though their salaries are on the Consolidated Fund of State. So they have a sort of independence in their office, because nobody can vote down their salary. That goes against in their disadvantage. So even the Supreme Court of India, in this case of T.N. Seshan, who was one of the most prolific chief election commissioners of India, brought about a lot of reforms in how election was conducted in India. So this case pertains to 1995, where the Supreme Court itself made a point that the chief election commissioner is not superior to the election commissioners, but at the same time you have to ensure that the salary and the independence of the office is maintained. And the present constitutional guarantee is inadequate and requires an amendment to provide the same protection and safeguard in the matter of removability of election commissioners as recommended by the Law Commission in its 255th report. Now, what challenge in this is, you have 3-member commission. One is the chief election commissioner, the other two are the other election commissioner. So the independence of office or security of tenure is only available with the chief election commissioners. The chief election commissioner, who is a single person. Now, the other 2 election commissioner, in every other aspect, they are equal. So the decision is, the decision will be on a basis of majority vote. Whatever they decide will be on the basis of voting. Their perks, privileges, everything is the same. It's only when you talk about the removal or the independence of office, the office here is different for the chief election commissioner and the other 2 election commissioners. Now, this is something that has been a bone of contention for a very long time. probably the constitutional makers initially thought that we do not need a multi-member body, but they at least were wise enough to include a provision which said that probably in future, if the president feels like he or she can increase the number of election commissioners. So the only security of tenure is provided to the chief election commissioner. He or she can only be removed in the manner of a Supreme Court judge. That means that if you have to remove the chief election commissioner, you will have to go to the parliament. Both Lok Sabha and Raj Sabha have to bring about a special majority vote in order to remove that person from the post of a chief election commissioner. On the other hand, the other two election commissioners can just be removed by the recommendation of the chief election commissioner to the president. So this is a sort of disparity in the commission itself, that the chief election commissioner is same in every aspect with the other two election commissioners. But when you talk about the removal or the independence of the tenure, or when you talk about the security of tenure of the other election commissioners, those two are unequal. So this has been one of the major concerns for the functioning of Election Commission of India as well. So probably the parliament has to take a call on this, because they will have to bring about a suitable amendment. Now, moving on, about the staff, as I mentioned, that they do not have a separate secretariat. So that means they do not have the freedom to even appoint their own staff. Now, considering the kind of mammoth exercise that the Election Commission of India is engaged in, from Ladakh to Kanyakumari and even to Lakshadweep to Andaman and Nicobar Islands, in organizing the election in a free and fair manner, they of course need an independence to appoint their own staff. At the same time, they should also have independence of their salary, independence of the budget, which is actually missing in India. And therefore, again, in this context, the Law Commission has recommended and endorsed the view that they need a separate secretariat for their effective functioning. Now, Venkaiah Naidu Saab, the Vice President of India, recently gave a lecture regarding the electoral reforms in India. So he mentioned that India, is a very vibrant democracy, and Vice President Naidu Saab has termed Indian experience of democracy as a remarkable success story. However, he was also, highlighted the fact that there are two distortions which need to be addressed urgently. First is regarding the how the elections are conducted and the increasing attempts to entice the voters with short-term benefits at the cost of long-term goals of basic amenities, infrastructure, quality, education, healthcare, growth, and job opportunities. So nowadays, it's very common and an unfortunate scenario that still in India, at the, we are celebrating 75 years of independence. We were celebrating the Azadi Ka Amrit Mahotsav. But this is also very unfortunate that in India, voting majority, is based on the lines of caste, community, and religion. So the communal angle, which has been brought about during the election, that is something that needs to be looked upon. And similarly, the other big concern affecting elections in India is the criminalization of politics. One of the most landmark cases talking about this issue is the Lily Thomas versus Union of India case, where the court held that the Section 8 subclause 4 of the RPA 1951 is unconstitutional, which allows the MPs and the MLAs, the legislators, who are convicted to continue in office till an appeal against such conviction is disposed of. So this was basically done away with in the Lily Thomas case. Earlier, what used to happen, even if the MP and the MLA are, they have been, arrested under a certain case, they continue to remain in office. But now, as you know, if you're convicted for in a criminal case of more than 2 years, you stand disqualified from elections for next 6 years also. So the scenario is, for example, let's say you're convicted in a case for, let's say, 3 years, or let's say you got a punishment for 5 years. So once you come out of the jail also, you'll still be debarred for the next 6 years. So it's not total. It's basically once you serve the entire punishment tenure, and after you come out of the jail, after finishing your sentence, you will have to you'll be continued to be disbarred for the next 6 years. Of course, Election Commission of India has certain, you can say, flexibility, as it was seen in the recent case of Sikkim's chief minister under the Prevention of Corruption Act. So they have this certain flexibility in case the case involves conviction which is less than 2 years. In that scenario, the Election Commission has a certain bit of flexibility in reducing the term of disbarment. So I was talking on the point of criminalization of politics, which is one of the biggest issues concerning the electoral system in India. So based on that, there have been several committees which have been appointed, and they have recommended certain amendments. Of course, the list is pretty huge. And today, because of the limited time, we will not be able to go through the entire list of amendments. But still, I would try to give you some of the most important ones that have been recommended for reforming our electoral system in India, especially the amendments that have been recommended in the RPA 1951. So some of the most famous committees are the Goswami Committee, the Vohra Committee, the Gupta Committee, the Law Commission Report on Electoral Laws, the National Commission to Review the Working of Constitution in 2001, the Election Commission of India, Proposed Electoral Reforms, and the second ARC Reforms Commission Report in 2008. So all of them have recommended certain amendments. Sorry. So first of the most important amendments that has been recommended, because see, you have to understand that RPA 1951 is the main law. Apart from everything else that is being used to conduct elections in India, the rules and regulation, sorry. The most important electoral law in country right now is the RPA 1951. It has such plethora and wide provisions, right from how many seats a candidate can conduct, basically contest elections from. Similarly, from the provision regarding the registration of political parties, disqualification. So it is a very, very wide law, but as you know, is with the Constitution of India, which is follows a living tree approach, as our Justice, Honorable Justice Chandrachud has mentioned it time and again, and the previous Supreme Court judges also, that in India the laws also need to change according to the changing nature of society, and similarly the Constitution also evolves over the period of time. So there is, I think, an urgent need to amend some of the major provisions of the Constitution of India. Also, when we talk about simultaneous elections as proposed by Honorable Prime Minister Narendra Modi ji, at the same time, there is an urgent need to amend a lot of provisions in RPA 1951 also, to ensure that we are able to protect our vibrant democracy. So the first one is that the section 125A of the RPA should provide for more stringent punishment for concealing or providing wrong information on Form 26 of Conduct of Election Rules, to minimum 2 years of imprisonment, and removing the alternative punishment of a fine. So right now, the only punishment available is in this context is a fine, but then there has been a recommendation to amend this for giving false information in your affidavit also will be subject to a penalty of 2 years of imprisonment. So the second ARC also recommended that the section 8 of the RPA 1951 should be amended, because it allows for a person to be disqualified on the charge relating to grave and heinous offenses of corruption. Similarly, one of the you can say problems in elections in India is, apart from criminalization of politics, is the use of money and muscle power. So you have a lot of these Bahubali netas, Bahubalis who are former criminals. I think we have seen a lot of these so-called Netflix or Amazon Prime series, where you see a lot of these criminals becoming politicians just because they have money and they're able to support politicians. So that is a very, very common feature in India. And in fact, when I started this lecture, I had highlighted this fact, this scenario, the numbers, where a non-profit organization, ADR, reflecting the number of criminals that are actually in Indian politics. So one, favored suggestion or favored amendment is the curtailing the role of money power in politics. Now you have independent observers, you have electoral observers, you have financial observers who are deputed for this task by Election Commission of India. So you have your IRS officers and other officers from the bureaucracy, executive. They are being designated during entire electoral process as financial observers. But the problem is not the observer, of the observing the election expenditure that is incurred at that time. The problem starts way, before itself, when you're talking about the campaigning and the canvassing period, right to issuing of the present electoral bond. So the problem is very deeply entrenched. It is not something which can be weeded out or can be removed or can be cured in just one day or just, by passing an amendment to the RPA. So majority of the candidates, if you see, who are contesting election, they declared in their election expenditure to the EC that they had spent between 45 to 55% of the limit, and only a few candidates declared that they have spent 90 to 95% of the limit. Now, election in India is an expensive exercise. We have to be honest with ourselves. India में election बिना पैसे के नहीं जीत सकते हो. ठीक है, I'll be very blunt about it. One thing that I'm with my students is very honest and being blunt, irrespective of however the scenario is. If you want to win an election, no matter how much famous you are, no matter, doesn't matter how many people know you or how many people will vote for you, it is a harsh reality that in India, to win an election, you will need money. Either you contest as an independent candidate, still you will have to carry out your own expenditure, or majorly what people do is they are portrayed or basically given a ticket by the political parties. Because the reason is, as a candidate, you have a certain limit on the amount of expenditure that varies from state to state in the case of assembly elections, because of the extent of the state. You have more expenditures in a larger state considering on canvassing and traveling. And so it varies from state to state. But apart from the limitations which have been set by the EC revises this, from time to time, the electoral expenditure that can be incurred by a candidate, the party from behind spends a lot of money on you. So one of the reasons why you see a lot of criminal or people, from criminal background being given party tickets to contest election is because of the fact they are banking on you on the basis of your winnability. It does not matter whether you have a criminal background or you do not have a criminal background. If they see that you have the potential to win, they are going to back you. And having said that, most of the criminals, either by coercion or by luring people or by using money power, they have this winnability factor. That is one of the major reasons why you see political parties going in favor, irrespective of whatever they might say, whatever their ideologies be. This is something which is common in the entire political spectrum of India, that people from criminal background are preferred because they have what is known as the winnability factor. So in fact, most of the previous committees that we had talked about has mentioned about how to reform this. So again, recently, in fact, I remember the Supreme Court of India in 2018 passed a judgment where they asked the parliament to make a law on banning of criminal politicians. In fact, they had even asked the state government and central government to approve and set up fast track courts. So in fact, there was a recent judgment again 4-5 months back where the Supreme Court asked about the status of the establishment of fast track courts to conduct trial for these tainted politicians or tainted MP and MLAs. But as of now, there are very few which are functioning, and as of now, we have not really seen any such reforms taking place on the ground. And so that's one of the most important factor is that the parties always are backing the candidate which have the biggest winnability factor. And sometimes I would also like to highlight this fact that I think sometimes it is an opportunity which is missed by the courts also. For example, a lot of times courts have the power, or you can say rather than power, it is the opportunity for the court also to basically instruct, I would say, they can pass a ruling or a judgment. For example, recently what they did was again on that the candidates have to declare their criminal cases on the website. All political parties have to ensure that the candidates who have a tainted record, that has to be published on the website of the political parties. I think that was a very a good judgment. But at the same time, I think sometimes the courts need to be a little more strict, if I may, would say, and not everything can be, pushed to the parliament, because eventually when we talk about elections and electoral laws, I think every political party becomes one. So it's not just about whether one political party will do it or the other political party will do it. In terms of electoral reforms, I think it has to be a combined effort. So one of the other issues that affects political system in India is the Right to Information Act, and also about this, whether the political parties come under the ambit of the RTI Act or not. So there was a very landmark judgment of Supreme Court, and then again there was a case regarding the Chief Information Commissioner, regarding the DAV College Trust and Management Society. So political parties in India are not considered as public authority. So that is why they are not bound to give information if you file an RTI. Now, as you know, RTI is like a fundamental right nowadays. It's governed by principles of Article 19 and freedom of speech. At the same time, right to know under Article 21. But the foundation to give reply in these matters lies with the public authority. But political parties are not public authorities as of now. But what this judgment did, the DAV College Trust and Management Society judgment did was, it for the first time highlighted how a private body like an NGO can even be considered as a public authority if the private party or the NGO or any private body uses substantial amount of funding from the government or the public. Now, how political parties come into this picture? If this judgment is extended to them, they will definitely come into this ambit. When, we do not know. But the criteria is, because political parties get free airtime when they are doing campaigning and polling, they use public broadcaster like All India Radio, Raj Sabha TV, which is now Sunset TV now, Doordarshan. They are given the land at subsidized rate in the national capital that is based out of taxpayers' money. So in totality, the amount of subsidy or the money that is being spent on political parties is something which is a very significant public money. So under that criteria, political parties, according to Supreme Court judgment of DAV College Trust, should come under the ambit of right to information. But as you know, they don't. As of now, nobody complies with the order. Then the other issue is, of course, of the caste and religion-based politics. So the court has said that any candidate seeking vote in the name of caste, religion will be banned immediately under Section 123 of the RPA. Similarly, bribery, corrupt practices, those are all banned under the RPA 1951. The other major concern, I would like to just take 5 more minutes on highlighting these issues. So the other major concern that needs significant reform in India is Section 29A of the RPA. Now, this is very interesting that in India, the Election Commission of India has the power to register political parties, but they cannot deregister any political party. Do you know how many political parties exist in India as of now? There are more than 8,000. We hardly know about 5 to 10, maximum 6, 7. There are more than 8,000 registered political parties in India. Now, what do these 7,500 or 7,600 political parties do? Most of these are shell parties. They act like shell companies. What they are doing is they are just funneling black money for bigger political parties and then using it to channel those funds for electoral gains. So most of these political parties, the shadow political parties, which are just created just to channelize these funds for narrow political gains. So one of the most sought after amendment by Election Commission of India is this power to deregister political party. So Election Commission as of now cannot deregister any political party. And that's an irony again, because most of the time the Election Commission of India has to prepare the list. They have to prepare these voting machines according to the number of political parties and the candidates. So what happens is that most of these small so-called parties are functioning at the behest of these bigger political parties. That is something that has to be really looked upon. Apart from that, the last issue that I would like to address, the last 2 issues that I would like to address regarding electoral reforms in India would be, firstly, is about electoral bonds. Now, electoral bonds, when they were brought in, the idea was to increase transparency and accountability in electoral fundings in India. The idea was to have a feature where, these so-called bonds, it's like an instrument where you pay money and this is like a certificate which shows that, you have contributed to certain political party. So these bonds are issued by SBI only through certain specified months when the elections are about to happen. The government advises SBI to allow this, and then in accordance to the rule. So the bonds start from 1,000 rupees, go into 10,000, multiples of 10,000, 1 lakh, 10 lakh, 1 crore, etc. Now, what happens in this is that anybody, any interested person or a party can, even NRIs now can, or a foreign person can actually, purchase these bonds. They can mention for which political party they are going to, provide funding through this electoral bonds. The idea was that this cannot be used or misused to know which person or which private entity or corporate company has given electoral or funding or donation to a political party. But having said that, if you see this number, there's a unique number mentioned under OT 1055101. This unique number is known by the RBI and this unique number is known by the SBI. So considering that, there has been a lot of questions raised that do these unique number can lead to knowing of the fact that which person has voted or which person has donated through electoral bond to a certain political party. So there have been concerns about the anonymity. So now what happens is there was a recent court case regarding a trust where the electoral trust under the trust clause has to give every information about the political funding under the Trusts Act. But because they had used an electoral bond to fund the political party, they denied that information to the authorities. Because electoral bond was conceived with the idea that it will bring in transparency and anonymity. On the other hand, if you really see what has been happening is that you really do not know which person, which political entity is being funded, by these bonds. And earlier there was a limitation on the amount of profit a company makes, and which companies can contribute to the funding of electoral bonds. Now that limit is gone. So anybody, even a shell company, which is not existent in reality, it is just existing on paper, can use this electoral bond to fund elections in India. So the 7.5% cap was there earlier on corporate donation. Now this is gone. Last but not the least is about the defection law. So anti-defection law was incorporated into the constitution in 1985. This was about the very famous Ayaram Gayaram case. Because our constitutional fathers never thought of this scenario or a situation where a legislator would switch parties, 3-4 times in a day itself for their political gains. So anti-defection law, the bigger problem is that in anti-defection law, there are two main issues. Firstly, the power to disqualify under the provision is with the Speaker or the Chairman of the House. Secondly, there is no timeline mentioned in the Constitution or any law on when can the matter be decided by the Speaker of the House. Thirdly, the power to disqualify under this lies with the person who is appointed, or you can say that has been appointed or elected to the chair from a majority party, even though it is considered that once you are in that chair, you have to be non-transparent and non-partisan and non-biased. But inevitably, we all are human beings, and there are political scenarios and political considerations to take place and to consider. So that is why a lot of times the Election Commission and even the Supreme Court had to reverse the judgment, had to reinstate governments, in fact, under the anti-defection provisions. So Karnataka case, Madhya Pradesh case, Arunachal Pradesh case, Uttarakhand case, all of these cases highlight the fact that there's an urgent need to amend the anti-defection law provisions in India. And one of the major provision was answered during the Kyoto Holohan case of 92, where it said that the anti-defection law in India, does it prevent freedom of speech? The Supreme Court said no, but still they agreed to the fact that it needs urgent modification. Why? Because when I initially started the lecture, I talked about that we follow a Westminster form of government. That means our system is borrowed from the British Parliament system. You would be glad to know, rather, surprised to know that in British Parliament, the member of parliaments of the same party can criticize their own government. But that is somewhat not really acceptable in India. So their anti-defection law is not applicable if you are talking or criticizing your own political party. But that scenario does not really happen in India. So having said that, there are a lot of provisions which are required to be changed and to be amended. And separately, there are other issues also on banning of exit polls, Income Tax Act, that also need to be amended from time to time. And of course, the role of media, very, very critical. The role of mass media, the paid news, journalism, that they also have to realize the role they are playing, especially wo breaking news ke chakkar mein kya hota hai, they are actually breaking the nation. I commonly say to my students is that ye breaking news ki bheed ke chakkar mein, what the media really is doing right now these days is that they are breaking the nation. So I think that is something that we really need to look upon. Rest other are common proposals and about simultaneous elections. So I think that is it from my side regarding the topic and the issue. If there is anything, any question, I would be more than happy to answer them.
Thank you, sir. And so your session was really flawless. Means you gave a lot many of information. Though you have covered all the topics, sir, there are few questions.
Yes.
Sir, one question is, we have anti-defection law in place for any single party. However, they don't apply for pre-poll registered coalition.
Yes.
For this,
Okay. So I think this question has been asked by Akshay.
yes,
Akshay
sir.
Deshpande,
Akshay
yeah.
Deshpande.
So see, what happens in anti-defection is, see, first of all, you need to understand that in anti-defection law, there are 3-4 different ways how the defection can be applied. So either you have voluntarily given up, resigned from the party, or you have, done anything which goes against the whip order, that is known as the, the chief whip or the 3-line whip which is issued, or you have done something, which, is in the violation of the provisions of the party. So the party can issue a motion in the House of defection. Most of the time, this is related to your how your actions are in the House. But one of the recent cases of JDU, Mr. Sharad Yadav, has been that he attended a political rally which was organized by the opposition party. And the Vice President of India disqualified him and the other person on the basis of the ground that you are engaged in an anti-party activity. So when they challenged it in the Supreme Court actually sided with the decision of the chairman. And they said that once you are, engaged in an anti-party activity, so the term voluntary giving up resignation to the party is a very, very wide term. So the Supreme Court interpreted that as that something that even if what you do something inside the House, at the same time, something that you do outside the House can also be interpreted as anti-party activity. So if you're, regularly attending meetings organized by an opposition or a major opposition to the main party or the government, that means you have given up the voluntary, resignation of that position. As far as the pre-coalition is concerned, see, what happens is that there are certain guidelines which are mentioned based on the recommendation of Sarkaria Commission, Punchi Commission. For example, let's say if certain political party does not have majority, what does the governor has to do? That the order is given that they should first look at the possibility of a government being formed either through pre-poll alliance or post-election alliance. Similarly, in case of anti-defection law, earlier what used to happen was the defection was allowed on the basis of 1/3 split. That later on was amended. Now you can only be prevented, or you can only prevent from being disqualified under anti-defection law is if the split is 2/3. So it does not really matter if it's a pre-poll alliance or a post-poll alliance. If you are splitting the party where majority of people are splitting, that means if 2/3 people are splitting, then it will not be considered as a defection. Both the set of person, whether part of 2/3 and the remaining 1/3 will not stand disqualified.
Okay. Sir, actually, my question was not on the anti-defection, like in a single party. Okay. But there are scenarios like, see, pre-poll registered coalition is there. Yeah. There are, say, multiple parties, 3, 4, or 2, 3 parties. It's a common thing nowadays in right. Indian politics. Right. So what happens, like, say, there are 100 is the majority, and there are 3 parties which are there. But some parties are subsequently like a smaller number of MLAs they are holding, consider this is a state election. What actually happens, like this 2/3 or 1/3, whatever we calculate, that should be, what my point was, that should be actually on the complete total number of the coalition that should be calculated. Right. Not the individual party. When the parties formed a pre-poll coalition on, say, a common minimum program, right. They should be considered a single party, at least for that elected term. Why it's not happening? Okay, so to answer your question, first thing is that when you're talking about anti-defection, so defection happens for a member. It does not happen for a government. We have to firstly separate that. What you're trying to say, if I'm understanding correctly, is that in a pre-poll alliance, let's say there's a coalition. So there are 3, 4 different parties, who have come together to form a government.
Now, when the anti-defection law should be applied, you're asking that it should apply on the total number and not on the political party. But that goes against the very principle of defection, because defection is not from the government. Defection is from the political party. So irrespective of whether you are in a coalition or not, your anti-defection law will be applicable because you have contested election from a certain political party. So that party or any other member can file an anti-defection case against you in the House. And that is also the premise, because when anti-defection happens, you are not following the orders of the political party which has backed you in the election. So what you're really, actually a little confused about is that we are not looking at the government defection. It does not lead to whether the government falls or stays. It's about whether the member stays in the House or not. Actually, I hope I've been able to answer your question. I think you have to unmute yourself. Yeah.
Yes, sir. The next question is, sir, can you please cover on the issue of bogus vote and how we can remove it? There any constitutional measure or law against it?
Achha, yeah, I think this is from Preetham. Can you please cover on the issue of bogus votes and how can we remove it? Is there any constitutional measure or law against it? I have tracked more than 18,000 bogus voter ID cards of 2000 Pimpri Assembly vote also come to the Pimpri Assembly. Okay. See, in the beginning of the lecture, I had talked about the electoral rolls. So, EPIC card is issued for voting in India. But do you know that any identity card can be used to vote in India? It's not just the EPIC card. You can take any of your ID cards and go and vote in the election if your name is in the electoral list. I think one thing that needs to be done regarding bogus voting is not one. In fact, there are two things. Firstly, that the electoral rolls need to be updated frequently. I think not just before elections. I think they should be done at a much more regular intervals. Because I think what happens is before election, now you know that the election is going to happen and you are residing in a particular area, so your name will be there in the electoral roll. So sometimes it might happen, some bogus voter might come to a specific area and they will get their EPIC card created and they get their names registered into the electoral rolls. So I think one major way how we can do it is having that updation exercise being done on a more regular basis. The other, of course, is about that's already been done on a certain scale is the use of VVPAT. So VVPAT actually tells you the candidate or the party that you have voted for, and there's a paper trail which comes around with it. So I think a lot of times it's being used to match the vote, but that is not a very regular feature. So I think if you count the number of voters in a constituency and the amount of votes that had been recorded in the EVM, and then you match it with the VVPAT, I think one of the ways how it can be done is matching each and every VVPAT with the the EVM voting machine. But that is something that should only happen once the Election Commission has a lot of expenditure and a budget of their own to have these many VVPATs with them. Because right now the biggest issue is that they do not have so many VVPATs available with them. I think we can take the question. I think there's one on Akansha. I think there's one on education qualification for political leaders. I think I would like to answer the question also. Yeah. So yes, the reason for not having a educational qualification for being a politician in India is something which is very controversial and debatable. Having seen that at the grassroots of democracy in Panchayati Raj and in urban body elections, the Supreme Court, in fact, a lot of states like Odisha, Haryana, Bihar, Rajasthan, UP, they have passed legislation on a certain minimum educational qualification that either you need to be 10th pass or graduate. Even in fact, to an extent that they have made their laws regarding whether you're having one child or two child in Odisha, for example, or even whether you have a functionable toilet or not in the case of Bihar. So I think this is something which will take time because generally we have to understand education and wisdom are two different things. So somebody who might be educated might not have the wisdom or the experience to run a government, but at the same time, somebody who is less educated might be having more wisdom based on the experience to run the government. So I think there are plethora of examples where people who might be, a graduate from Harvard but they are not probably able to run that ministry efficiently. But at the same time, you have some people who might not be that literate enough, but they are able to, run the government more efficiently. But having said that, I agree that there should be, a criteria, but that comes with the fact that India is such a huge country with such diversity. This education criteria is more applicable to countries which have direct democracies like Switzerland, Norway, Finland, which have higher development index, and the people, the average literacy is much, much higher as compared to the rest of the world. So considering the, the poverty rates in India, the challenges in India a common man faces, I think it's very unjustified. It will be unjustified to have a education criteria in elections as of now. But yes, to start with, I think what we can probably do is have a education criteria. At least, every legislator should be educated enough, at least till class 10th and 12th. Now, why I support that is because once you're handling a ministry, you're handling a file and thousands of crores of budget. So you need to be aware that, what is right and what is wrong. You just cannot rely always on the bureaucrats. So having said that, I do agree that we need at least a basic minimum education level of class 10th or 12th, where they know about the basic, literacy, the numbers, especially mathematics, because when they are handling the government at the scale of, budgets of thousands and crores and lakhs of crores, I think that is very important.
So next, should I ask next question?
Yeah, sure.
So next question is from Vijay Deep. How much time Indian government will take to reform the electoral system to scrap the existing first past the poll system and incorporate the proportional representation system in India?
Okay, this is something which is again very recent. So as you know that in India, we have both the system. We have the first past the post and the proportional representation system by means of single transferable vote. Now, this system was incorporated by the Constituent Assembly, having seen the challenges of India, and also because we were pretty much used to the Westminster form of government, through the major acts and policies of the British government. So in India, for the elections of Raj Sabha and presidential elections and the vice president election, we have the system known as the proportional representation by means of single transferable vote, where you have a preferred choice, that whether you prefer candidate A, B, C, or D, or rather, but you cannot have a zero vote. You just cannot vote. You cannot exercise nota. On the other hand, the first past the post system means जो पहले poll को cross कर जाए. That is why it is known as first past the post. If you win the election, even if by one vote, you have won the election. So that is which is generally followed in the case of general election to assembly or the Lok Sabha. Now, the reason for that is that a candidate is winning election on the basis of his popularity or her popularity. The only concern with the first past the post system is that a lot of time, what we may assume to be a majority vote is a minority vote. So for example, just to give you an idea, is let's say the percentage of voters who have come out and voted in the last general election is 61%. The population of India is around 135 crores. So just take out 61% of 61% out of the eligible voters. So let's say out of 135 crores, 90 crore was eligible to vote. So out of 90 crores, only 61% people voted. So that comes around to a very minority number of only 30%. So when you say that, I have the majority vote or the majority of Indians have voted for me, that's not actually true. You have won the election on the basis of a minority vote. Only 30% of eligible voters in India have voted for your government. So if you see the vote percentage of Congress and BJP or the NDA and UPA, you will see there's hardly any difference, 36 to 33%. So that means Congress is not less liked. It's just because of the first past the post system, a candidate has won the election because they have got one or two, even just one vote extra. Now, coming to your the last aspect of your question, when will the government reform this? This is something that will not change. Let me be very honest with you. The first past the post system is here to stay, because that is working on the principle, on the basis where how your general elections are conducted. Because why, I'll tell you why it will not change is, in a proportional system or proportional voting system, what it does is that it gives benefit to every political party. Proportional representation system ensures that at least every candidate, at least one candidate from every political party will get into power or will win election. Now, that is something which will hamper the growth of regional political parties, and they will never allow this. Even if the parliament wants to do it, they will need to have a constitutional amendment ratified by half of the states. That is never going to happen. So that is why you can't expect in any near future where the first past the post system is going to go.
Sir, from Gaurav, there is one question.
Yeah.
Why judiciary and election commission are failed to amend the amendment? Because most of the time we are seeing our lawmaker are accused of murder, kidnapping, rape, and other crimes against women. He or she is declared his crime or convicted also sometime, but election commission is not resuming his membership. Latest case, Navneet Singh Rana, caste certificate misleading, convicted by Bombay High Court. His membership is still continue.
Okay, so as far as, I mean, if I have read the question properly, because I think the voice was cracking, Akansha, let me just quickly. So why Judicial Election Commission
Yes,
failed to amend the RPA? Because the time we are seeing a lawmakers accused. Okay, see, this is again something which even Supreme Court wants to know from the government. They're like, let us know when will you, when you are planning to amend the RPA. We are also looking forward to it. See, understand, when it's about politics, politicians do not really worry about political parties or political affiliations. It, transcends the boundary of politics when you talk about electoral reforms. No matter which government is in power, the basic essence of politics lies in the fact that political parties are a minority. And whenever you are in a minority, you will want to protect your things. So it is very difficult to say when will the parliament amend this, because the government or whosoever has majority in both the houses will have to take an initiative to amend the RPA. Very difficult to comment on when will it happen, when will this happen. At the same time, it is desirable, yes, for sure. Desirable in every aspect. I have highlighted in my lecture in the past one hour, what are the major amendments that have been demanded on the RPA. And I do hope that, some of them are brought in. But technically, honestly, it's under the the discretion of the parliament and the political party, more so in the hands of the government. So whichever government, whichever party has majority in Lok Sabha, if they are managed, if they can manage to convince the Raj Sabha, because convincing Raj Sabha is altogether a different challenge altogether. That also requires depth and diplomacy on multiple fronts. So you need to have majority on both the sides to pass the bill in the parliament. So I don't really see this also happening very soon. Of course, yes, it is desirable. Then I think there's one more question. Akansha, is there any question?
Yes, sir. One more question. In the light of recent controversy regarding the use of EVM in election, how can Election Commission ensure the trustworthiness of election in India? First, and second is, as we see the veracity of news nowadays, have gone very low in India, and we have entered in a post-truth era. Shouldn't the Election Commission take responsibility to save the voter from getting hacked mentally, as their decision to vote can be manipulated?
Okay, I'm glad, Harsh, that you have asked this question. I was waiting for this question because nobody had asked me this question on the tampering of the EVM machines. So, so this has been again a controversial issue in India about the so-called hacking of the EVMs. Now, let me assure you that there is no such thing as hacking. I am myself a computer engineer. I've worked in the field of electronics also. It's not possible to hack an EVM machine. Whatever you have seen in media is just a gimmick, just to get TRPs. So it's very safe because first of all, it is not connected to any network. So you cannot hack it even remotely through Wi-Fi. Whatever is there is a standalone system. Until unless somebody goes there, personally and hacks in front of all the CISF and CRPF officials, that's a different story. But that is next to impossible. But trust me, there is no such truth in EVM hacking. And to answer your second question, yes, I do agree that the post-truth challenge, poses a bigger challenge, not just in India, but in fact in the entire world. And I think the Election Commission has taken a lot of initiatives regarding this. They have come up with a few apps. In fact, they are promoting, right to vote, and they have this National Voters Day that they are celebrating. In fact, they have this fact checker also, which is managed by the PIB of Government of India. Similarly, Election Commission also has this, that if certain news is fake, you can just WhatsApp them and they will tell you whether that news is correct or whether that news is fake. So I think more than them, it is the responsibility of us as citizens also to be aware and not believe in the so-called WhatsApp university. At the same time, I also agree that which was my last point before I ended my lecture, is the role of mass media, and especially the media, to come out of this TRP and breaking news habit and focus on the nation building. And they are the fourth pillar of democracy, and it's high time I think they start acting like one.
I think, sir, last two questions. Should I?
Yeah, sure.
Sir, I just want to ask one question.
Sure, sir.
This EVS machine only.
Yeah.
Obviously, a computer-based chip or a processor will be there. Would it not be possible to manipulate that processor, by which, if I heard like that, wherever you, what we can cast vote, it goes to a particular political parties. I mean.
Okay. So, sir, if I understand your question, you're saying that in the EVM,
it has been set. It has been set in such a manner that.
Yeah.
It's set in such a manner that wherever you cast the vote, where in whose political, I mean,
I got a question. I think your voice is cracking, but I got a question. You are saying, if I'm wrong, let me just correct me, sir. I think what you're trying to say is that if I vote for a certain political party A, the vote goes for B.
Exactly. I hear like that. I'm not taking.
I have also come across it. So let me tell you again, that can happen. I do not disagree with that. That can happen, but that can only happen where the machines are being manufactured.
Yeah, exactly.
So because that is how the coding is done for a chip. But having said that, I would also say again this: if that would have been the case, then only one political party would have been winning all the elections. If because that is owned by that electronics, where Bharat Electricals Limited and the company which is engaged in manufacturing EVMs, that comes under the Government of India enterprise. So if that would have been the case, then only one political party would have been winning the election. I think then probably Bengal election results would have been different.
Yeah, and even in USA, they are how much technically advanced since they don't use EVS machine.
In USA, yes, they use a system of postal ballots and paper ballots, which I think is, a very tedious process. Yes, you're correct when you say, sir, that they are very advanced technologically, but they used to use EVM. Then later on, they again shifted back to this concept of, they used to have a version of electronic voting machines earlier. Later on, they shifted to postal ballots. Right. So, sir, the only reason I would say that, why we probably would not want to go back to a system in India is because the risk of booth capturing or manipulation is much more in postal or paper ballots. Postal, though, we will never have. I don't think so. We will ever have postal ballots. But paper ballots, the risk is more, because it's very easy to print a paper and put it into a box as considered to an electronic device, because most of the people do not have the technical knowledge to do so. So I think, and also why in America that is a system, though I would tell you, sir, that personally, America does not have the most efficient electoral process. I mean, even during the recent presidential election, there have been controversies whether, some of the postal ballots were, opened earlier, some of them were opened later. There's a certain cutoff date, which is very itself complicated. And also considering the fact that their electoral process is different because of the form of government. Because they favor a presidential system, we have a parliamentary system, which is technically not also possible to have, so-called, and such an extreme exercise of having postal ballots or a paper ballot system. So I think, yes, the system is not foolproof, or you can say perfect. I would say perfect nahi hai, but yes, I think the laws need to be modified and improved. And
yes,
Bharat
Electronics is also under the control of the government.
That's what I'm saying, sir. So that's what I'm saying. If that would have been the case, then only the central government would have been winning elections everywhere. If that would have been the case, considering the state of West Bengal is one of the most important ones for them.
Yeah, right.
Yes.
Thank you, sir.
Thank you, sir. Thank you.
Okay, sir.
I think one last question I would say takes from Pranay. I think Pranay is the organizer of Think India. So yes. I think it would be important to answer this question at least. So Pranay, thank you first of all for giving me this opportunity. Secondly, to answer your question, can email voting be the future of election in India? Yes. If we use blockchain technology, it can be very well done. I think also this is one thing that I would love to see in India is the blockchain based voting, because blockchain is something which cannot be manipulated unless you have a supercomputing power. So I think, yes, it can be done. It should be done, because it becomes very difficult for a person, especially nowadays. Now, let's say, COVID scenario may, if you have an election being organized. Now, if there is a travel restriction, your NRIs cannot come back and vote. So you cannot do it unless you're a service voter through postal ballot, you can do it. So I think email voting, in fact, Election Commission has already started testing this. They have already started this process of testing, this electronic voting system, or through, email voting system. I think in few years, this might happen. And in fact, I am a big supporter of it. Now, there can be another flip question is that, then wouldn't it, make it vulnerable to hacking and all? See, hacking is something which is inevitable, but then if it is based on blockchain, 99% of the time it is difficult to hack it. 1% possibility though can anyway always be there, because for blockchain hacking, you need a supercomputing power. And that is something which will not be available to a person. That probably can happen at the government level or at an institutional level. So yes, there is a possibility. And of course, it will have its own safeguards. So I think how it can be done is, firstly, that you can match the email votes with the real or physical votes. So what they can do is you can have a dual system, that you also take the the postal ballots of the people who are living in foreign countries, the NRIs, and you match it with the electronic vote. So I think there can be a dual check, something like that.
One last question: who is a service voter?
Service voters are classified as people who are engaged in military or administrative or diplomatic work. So they are basically posted in embassies. So you're, of course, your military person cannot leave the post and come back and vote in India. So they have this postal ballot system where they are, either they or any one of their spouses or anybody they designate can vote on their behalf. So those are known as service voters.
Okay, sir. Thank you so much. And we have utilized your lot of time.
It's absolutely all right.
Sir, last question of mine is, any book we should read for election system that we should understand?
For election system, see, there is not any specific book, but I think you people are law students yourself. So I generally have read D.D. Basu, Bakshi sir ki book hai, and I've read Granville Austin. Recently, there was a book by an author, Day, and he has talked about India's evolution of constitution. So he has discussed major judgments and evolution of constitution in India. So I think it's not just for election, it's just a very good book for a normal, if you want to know more about the constitution of India through various judgments. So I think you can refer to that book.
Okay, sir. Now I request Julie Patwardhan to come upon and give the vote of thanks. Thank you so much, sir.
Good afternoon, everyone. I am privileged to have gotten this opportunity of presenting the vote of thanks for today's session. I would like to express my heartfelt gratitude towards our guest speaker, Mr. Deepanshu Singh, for his valuable time and for giving such a wonderful lecture. This topic is extremely relevant in today's world, and being young voters, it was our privilege to know the views of such a great personality on the topic. Well, ladies and gentlemen, such an event cannot happen overnight. Wheels start rolling around a week ago. It requires planning and a bird's eye view for details. We have been fortunate enough to be supported by a team of very motivated and dedicated teachers and my colleagues from Dr. D.Y. Patil Law College and Think India Organization, Pimpri-Chinchwad. I am grateful to Dr. D.Y. Patil Unitech Society for giving constant support in all the activities we conduct in college. I would like to thank respected Dr. Ujjwala Shinde ma'am, our respected principal of Dr. D.Y. Patil Law College, for her relentless support and guidance. I would also like to thank all the coordinators of Think India organization for working so hard to make this event possible. Lastly, I would like to thank each one of our participants for joining us today and making today's event so lively and interactive. Thank you and have a nice day.
Thank you, everyone. Thank you. Thank you for having me. Thank you.
Thank you, sir.
Thank you, ma'am. Thank you. Thank you, sir.